we have enough people. Are going to go ahead and get started. So good afternoon, and welcome to the Committee for Justice's panel discussion, Antitrust Populism and the Rule of Law. I'm Ashley Baker. I'm the Director of Public Policy at the Committee for Justice, and I'm going to introduce the panelists in the order in which they're going to be speaking. We have a really exciting lineup here. First, we have Richard Epstein, who is the inaugural Laurence Tisch Professor of Law at NYU School of Law. Prior to joining the faculty, he was a visiting law professor at NYU from 2007 through 2009. He has served as the Peter and Kristen Bedford Senior Fellow at the Hoover Institution since 2000. Epstein is also the James Peter Hall Distinguished Service Professor of Law Emeritus and a senior lecturer at the University of Chicago. His initial law school appointment was at the University of Southern California from 1968 to 1972. He served as editor of the Journal of Legal Studies from 1981 to 1991 and the Journal of Law and Economics from 1991 to 2001. If panelists could please put themselves on mute while you're not speaking, I hear some paper ruffling and such, and it messes with the Zoom call quality. Thank you. And Professor Epstein has written numerous articles on a wide range of legal and interdisciplinary subjects. He has taught courses in administrative law, antitrust law, civil procedure, and about 100 different other vast areas that I won't list for benefit of time right now. Kristen Stout is the Associate Director of the International Center of Law and Economics and is an expert in intellectual property, antitrust, telecommunications, and internet governance. Kristen graduated magna cum laude from Rutgers University School of Law, served as the editorial board of the Rutgers Journal of Law and Public Policy, and was awarded a Governor's Executive Fellowship from the Eagleton Institute of Politics. A former fellow in the Internet Law and Policy Foundry, Kristen was previously a lecturer in computer science. Kristen is frequently invited to speak on law and technology policy and has been published in law journals and law treatises. He is licensed to practice law in New Jersey and Pennsylvania, is counsel at A&S Technologies, a software services firm, and is a member of the New Jersey State Advisory Committee to the United States Commission on Civil Rights. Dr. Mark Jamieson is the director and Gerald L. Gutner Professor at the Public Utility Research Center at the University of Florida, and is also director of the university's Digital Markets Initiative. Dr. Jamieson's current research topics include information technology development, regulation, and antitrust. Recent projects include the impacts of the iPhone and mobile broadband development, market power and big tech, the value of information technologies during the pandemic, and barriers to business adaptation. He has conducted education programs in numerous countries in Asia, Africa, Europe, the Caribbean, and North, South, and Central America. Dr. Jamieson is also a research associate with the UF Center for Public Policy Research and a visiting scholar with the American Enterprise Institute. A couple of housekeeping notes. So for the Q&A session, if you guys could please send me your questions through the Q&A function via Zoom, and you can go ahead and send me your questions during the discussion or during the panels, whenever you'd like, and I'll receive those on my end. And what I'll do is I'll introduce those at the end of the discussion element. That way I don't have to, enable your microphone. We don't have to have that moment of pause between the Q&A and the discussion. We can kind of keep things rolling. So if you can kindly send those in to me, that'd be really great. And with that said, Professor Epstein, the floor is yours.
You can't thank me. Thank you so much. It's a very great pleasure to be here to speak about this topic. And the first thing I would like to say about it before I give my substantive views is to relate a story that happened about now probably 20 years ago. There was a panel which was held at the DePaul Law School in honor of Ralph Nader and his work as an antitrust lawyer. And what Ralph did was to get up there and to announce that antitrust law was the cure for all evils, including various forms of corporate malfeasance, including various situations having to do with the then nascent science of client change and so forth. And I was sitting there as one of his commentators, and I said to myself, there is no tool in the legal system whatsoever that is the jack of all trades. If you are going to try to find something, what you have to do is to be able to match the particular body of law and the particular doctrines that you have with the particular problems. And it turns out that you will lose your way very badly if you try to make the antitrust laws apply to those things to which it does not do, because the great danger is then you'll misapply it to those things where it does do. And so I made that particular point, and that was, I thought, the end of it. And then 2 days later, I get a call from somebody in the audience, and he says, "We heard your position, and what we do is we have have an antitrust case that we are trying to undo the damage which took place at the trial court. There was a case involving an alleged, and actually I think a real cartel associated with the production of the various kinds of potash products that existed in Canada. And he said, we lost a very bad judgment in the district court in Minnesota. And now what we have to do is to get somebody who could take this thing up to the court and to make those liberals on the court see sense about the fact that cartelization is in fact a primary target of the antitrust law. And in this case, the evidence of cartelization was in fact overwhelming. And so the way the project worked is I was to persuade the Democratic judges to join the Republican judges who would already be versed in this particular kind of wisdom. And this was a case that was not only argued before a panel, which we won 2-1, but it was then taken en banc, and there were 11 judges on this panel. And when the whole thing was done, I looked at my clients, sadly, since I was largely on a contingent fee basis, and what I said is, I could tell you the position of every one of the judges, and we have lost this case 6-5. We were all unanimous on that, and this just tells you how the world works. The 5 Democratic judges on that particular panels all believed that it was important to control cartels, and the 6 Republican judges on that panel thought that it was extremely important that you make excuses with respect to cartels so that they are going to be allowed to flourish. And that's a kind of a lesson for you. It also turns out that, I've worked with Ralph Nader on other kinds of issues because I think on some of the stuff he does with respect to corporate malfeasance, he's pretty good when he sees the various kinds of rating. And that just makes the same point that I wanted to make again, which is the set of doctrines that you want to do with corporate misconduct have to do with the law of fiduciary duties. They do not have to do with the law of antitrust. Now, what do we think about the law of antitrust before we talk about the populism issue? I think, in effect, that the antitrust law basically has 2-3 categories. And if you keep the categories clear, you can organize most of the subject. And so the first situation that you have is horizontal arrangements, cartels, mergers, and things of that particular sort, where there's a strong theory which explains what the social potential danger is. And then what you can do is to work out a set of doctrines to figure out whether on a narrow basis there's some particular justification for this particular arrangement which should allow it to pass. On the other hand, if you have a vertical kind of an arrangement, the efficiency justifications of essentially getting rid of the multiple marginalization problem by having sequential elements put together in a single package is in fact a highly advanced efficiency situation. So now the presumption switches in favor of allowing these things to take place rather than against it. And indeed, in the United Shoe case, the mastermind who put this particular deal together was none other than Louis Brandeis, operating out of Boston in the first part of the 20th century. And the third set of cases are essentially sort of random cases, the predation cases and so forth, and the conglomerate damages cases. And by and large, in those particular situations, there's no particular peril, and you should let them go. Everything else, as far as I'm concerned, is explication about the way in which you execute the techniques needed to make this particular way of the problem start to work. Well, then the next particular question is, well, what is antitrust populism? Well, it's the modernization of the situations that we have with respect to Nader, only the objects today are somewhat different. And so when we start to talk about the weaponization of the antitrust laws, what happens is there are a whole variety of ways in which this can be done. One which is associated with the name Tim Wu, with whom I've had the pleasure of debating many times, starts to see the curse of bigness as the thing that we really have to be able to deal with. And what you do when you start having a curse of bigness is you want to break up companies for their own sake. And what you then have to ask is whether or not the integration produces certain kind of efficiency, which will be lost when you try to get these separations to take place. One illustration of how this can be quite futile was the Microsoft case back in 1998. If you try to figure out what is you going to do to break up Microsoft and to make it work, you could take the peripherals and put them in one corporation and the operating system and put it in the other. What would you achieve by that? Well, if the monopoly power lies in the operating system, it's still going to be there. And if it turns out there are efficiencies with integrated products on the peripheral side, you're going to lose those. This is not the kind of thing that we would want to have. And you have to be extremely careful about remedies that are designed to make sure that illicit practices don't take place, because what happened in that case is that IBM was able to manipulate the system so that every time Microsoft wanted to make an innovation, there was always going to have to be a hearing to see which way it would go. And this kind of aggressive antitrust stuff turns out, I think, to be really quite dangerous, because what you're doing is you're losing sight of the main point, which is to see how it is that you prevent counterproductive market arrangements from taking place, not to make sure that you take a large company and make it smaller, no matter what the economic consequences turn out to be. You note, for example, as another version of this today, you update with respect to Amazon. I'm no fan of the Washington Post, so this is not to be treated as an apologia with respect to Jeff Bezos. But on the other hand, when you see these various articles written starting to denounce Amazon on the grounds that it supplies effective goods at low prices, then you start to ask yourself just exactly what do you think this purpose is. And typically what people will say is, you have to worry about their nefarious political operations. And this then compounds an unmasked understanding about the general operation of the antitrust law with a general misunderstanding about the way in which the political process for rent seeking starts to take place. Fred McChesney, a dear friend, now passed on, basically wrote a very powerful set of articles saying, look, if you are very big, you can do things. But if you are very big, you can be made to do things that you don't want to do. So that when you're trying to figure out what the relationship is between size and political power, what you have to do is to understand the vulnerabilities are every bit as important as the gain. And so the moment you want to put this thing into political solution, it may well turn out to be that you're going to lose sight of the advantages that a company like Amazon has in its productive capacities and get very little in exchange. And the last thing I want to mention is a weaponization type situation. Is the whole situation today. American legal academics and American society at large has become fixated on the question of inequality and racial preference. And, I think these are very long and complicated debates. I have my own views about this. My view about inequality is if they create Pareto improvements, that is, if you can make somebody more better off than somebody else, you don't want MB to block this thing from taking place. And my view with respect to race is that there's simply nothing in the antitrust law which allows you to help that particular situation. But if you use it to force the monopoly power, sometimes the people have the fewest alternatives of those that are going to be way down on the bottom of the economic ladder. So you're going to very much hurt the people whom you would like to help. And so the correct answer, I think, in the situation in all of these cases is to simply say, we can't do anything of that here. You have to try something else. Think of a civil rights law, think of a progressive tax. I may disagree with you as to whether or not these remedies are going to be efficacious, but at least I'll say you're playing in the right court. So I think, in effect, if you keep the simple propositions of the antitrust law alive and well, the rest of the stuff will start to fall into place. If what you do is you try to turn it into a jack of all trades, it will turn out that it will be something which will be a master of none and will probably hurt collateral areas without giving you any advantage in the area in which antitrust law ought to work the best. And with that, I turn the microphone over to Christian.
To Dr. Jamison. Thank you, Professor Epstein.
Was I right on time?
Yes, you were right on time. Thank you. Dr. Jamison.
All right. Well, thank you very much. And I appreciate the opportunity to speak with everyone here today. So I agree with pretty much anything that Richard said in that space. So I'll talk about some things that are a little bit different, but some of the same topics, but just in a slightly different way. I think it's important to remember how we got to where we are with antitrust. That at one time, it really was a vehicle that people could use to go after others they did not like. If you read the history with Louis Brandeis, you could see that some of this was quite personal to him. And quite just kind of his view of the world, what he liked and what he did not like. And a lot of people pursued antitrust that way until we got into the 1970s, 1980s, when some people that largely supposedly affiliated with the Chicago school said, well, that doesn't look right. And what we should do is have some sort of a standard by which we measure whether or not antitrust is doing the right thing. They paused and thought, well, the economy is for consumers. We know that from reading Adam Smith a very long time ago. That's why we have an economy. So why not make antitrust focus on that as well? That gave us very objective metrics. It also took us away from being able to just go after enemies using antitrust tools, which we have seen happen from time to time. I think that we're also in a moment where the way we have done antitrust since that time is now under challenge, not just from the populist type movements, but also just from the way that digital markets work. Now, I won't go into all the ways that they're different than what we've seen in the past, but one of the keys is how dynamic they are, how fast they change. That we have, the technology is becoming more and more efficient on a very rapid scale, and then we have these periodic disruptions. Bell wrote a paper about that just a few years ago and said every 10 years we have some sort of major disruption that changes everything. And so in that kind of a context, it's really hard to do antitrust the way that we have. It's very difficult to look at what a market is doing, to say this is good or bad or indifferent, and then decide how you're going to act. Because by the time you've done all your studies, you're talking about some history that is just not relevant for the future at all. So I think that what we need to be thinking about is a way of taking the focus off of outcomes that we decide we like or dislike, and instead going back to how Adam Smith and John Stuart Mill talked about the problem of monopoly. When they were doing some of the very foundations of economics, they said, what causes something to be a monopoly so that it doesn't have to be responsive to customers? And they centered on, they drilled down on an issue that, this is my phrasing, that there's some sort of endowment, something that keeps this company or protects this company from competition. And I think we're going to have to go back to looking for those types of items rather than look at market outcomes and saying we like or dislike them. Let's look at what would be the endowments that give market power and try to deal with those more directly. Let me step back then to the populism issue. And here, Richard's really laid it out quite well. Essentially, what people are talking about is creating some sort of commercial czar. And if you allow someone the authority to shape markets, shape companies any way they see fit, one, you're making a tremendous assumption that someone actually has the wisdom to do that, which Louis Brandeis would disagree with. He didn't think people were smart enough to do that kind of a thing. The neo-Brandeisans tend to think people are, but so that's a real problem. But what happens, because we've seen this all over the world, what happens when you give someone that kind of authority? They tend to use it for their own personal ends and for the ends of their friends. So rent seeking goes rampant. That is the main way to succeed, is by having friends in the government, making sure your political allies are the ones that are there, and to be sure that what the laws are doing is protecting you from competition so that you get your way. So one of the most wonderful things you can be is a regulated monopoly, because you're just not going to face the customers. All you have to face is the government regulator. So I'll wrap up there, Ashley, and let Christian take it from here.
Thank you. Questions?
Thanks, Mark. Thanks, Richard. Thank you also to Ashley for the invitation to speak today, and to the Committee for Justice for putting this together. I think it's a really interesting discussion. I'm going to keep my comments brief so we can move to the discussion section. And I think most of what I'm about to say is largely aligned with what Richard and Mark had to say. So I'll try to focus on a few points that I think are the most important to understand about what's going on with the populist antitrust movement, and hopefully I won't be too duplicative. Populist critics of modern antitrust law, they don't have a single coherent project that can be easily ascertained. What's presented instead is something of a grab bag of criticisms and propose remedies that aren't exactly anchored to a specific guiding standard. I think, indeed, one of the common thread that you will find in the populist antitrust rhetoric is a wish to move away from the consumer welfare standard that Richard and Mark mentioned, which currently serves as a lodestone for antitrust analysis. One of the main virtues of the consumer welfare standard is that, as Mark alluded to and Richard mentioned, that it limits political discretion. I think it does this by smoothing out doctrinal shifts that would occur across administrations without some sort of neutral standard to guide antitrust analysis. And that without such a standard, these administrations would be able to seek particular worldviews through antitrust law rather than treating it as a neutrally administered body of law. To go to the topic of this discussion, to actual function as a rule of law as opposed to a source of political discretion. Populist critics maintain that basically any institutional arrangement is in fact an expression of political preference, and I think they're correct when they say that. But I think that they think that their observation proves more than it actually does. The chief objection that the populists have when they want to revert to a more antiquated state of antitrust enforcement that Mark mentioned from the early 20th century is that the expression of political preferences in their arrangement becomes unmoored from broad democratic accountability and becomes subject to the whims of enforcers in the executive branch. But these facile observations that all enforcement structures are expressions of political views, I don't think they contribute much to the central question that functions, or one of the central questions that's important in our democracy, and that's how do you channel the broad democratic political will that establishes antitrust law? How do you channel that through enforcement structures that are subject to explicit and implicit capture? I think that's why the consumer welfare standard came to exist and why it evolved over the course of the 20th century. The consumer welfare standard, it doesn't dictate the particulars of any particular case ex ante, but it prescribes the creation of testable, relatively objective metrics by which to gauge competition and competitive harms. A consumer welfare standard doesn't require any particular doctrinal rules. Instead, it requires only that when doctrine is adopted, its analysis is grounded in one ultimate question: are consumers better or worse off as a result of behavior that's being challenged? A new standard to replace the consumer welfare standard is not per se bad, but it is going to be subject to reasonable skepticism, particularly since the current standard is very flexible and capable of incorporating new theories as empirical evidence emerges to challenge existing theories. But the changes that have been preferred by the populists so far aren't going to do the trick. And broadly, you can break them into two separate categories, and I think both of them are not particularly desirable if the populists have their ways. One set of changes that would be introduced would be to introduce simple bright line rules, something like what comes out of the Brandeisian flavored body of law from the early 20th century. For instance, drawing an arbitrary line with respect to market share thresholds. Economic theory and evidence has shown us, though, repeatedly that there really isn't a single bright line metric that you can apply for firm size across all firms in all industries. There isn't even a reliable range that you're going to be able to abstract from what we've seen in different industries and say that there is one ideal set or one ideal number of competitors that should apply across a broad range of industries. Some markets do very well when concentrated, relatively. Some don't do as well, and it comes down to an empirical examination of particular cases that guides the best analysis. The consumer welfare standard in this context tasks enforcers and courts with using evidence to pull apart the particulars of cases and determining when competition isn't functioning well. Bright line rules in this regard then, if we apply them in this kind of situation, would be both under and over inclusive, as they were in the 20th century, and they would be likely to generate net harm to society, as I think it's arguably the case happened in the enforcement of antitrust in the 20th century. A second set of proposals that comes out of the populists that is likewise not very convincing is that, and this is something more that Richard and Mark were talking about earlier, is that enforcers should consider a range of values that are not obviously related to competition when administering the antitrust laws. For instance, the effects of vertical conduct and mergers on employment patterns or environmental quality. These are, as I think our panelists would acknowledge, these are valid issues to consider, but these are not issues for antitrust law, and trying to include them in the enforcement of antitrust law is a categorical mistake. How we deal with climate change and the opportunity to access employment are policy areas best dealt with in an open democratic forum like Congress. Shouldn't be lodged in arcane enforcement agencies like antitrust agencies. So including these policy areas in antitrust law would shift the responsibility for considering these issues into bodies of enforcement that are not suited for doing that, and it would rob voters of their agency through elected representatives by facilitating disturbing degrees of regulatory discretion within the executive branch. Antitrust agencies are not designed to function as meta legislation, nor should we desire them to do that. That's a function that should be reserved for Congress. And finally, there's a fundamental error that I think drives much of these de-evolutionary populist pushes. They presume that political power necessarily follows economic power, and as I read the literature, such a relationship does not in fact exist. And following this sort of populist intuition can lead us astray and lead to damaging policy. The fact is that there is not actually any empirical research that persuasively demonstrates that large firms are any more likely to capture the political process than small and medium-sized firms, particularly when they act in coalitions. When you look at the top 50 US companies by market cap, there's at best a weak relationship between the size of the firm and their lobbying footprint. And in fact, if lobbying, and this is well-known Tulloch paradox, if lobbying were in fact such a surefire way to achieve the ends, you would see far more resources directed toward lobbying. So the argument that large firms, by their very nature, hurt the democratic process is unpersuasive on that account. If anything, I think we would expect to see relatively more outsized influence from coalitions of small and medium-sized firms functioning in congressional districts that are able to deliver votes to particular politicians, which is, as we know, the lifeblood of elected office. And related to this, if we think through the populist project to try to break up large firms or cap the size of large firms and thereby logically increase the amount of smaller firms in the economy, and to do this through introducing political discretion, you actually end up at a perverse end. What ends up happening is, with a larger number of firms operating in an antitrust environment ruled by political discretion, there's relatively greater incentive to attempt capture of the agencies and elected representatives to try to obtain exemptions for particular firms and particular districts. What you get is less of a uniform body of law that's applied neutrally across many firms, and you get something like the tax code, which is patchily administered based on who lobbied particular agencies and congressmen best. Ultimately, conflating economic and political power, even though it provides a lot of fiery rhetoric for populists, I think it does very little to actually inform modern antitrust law. If we want to have a neutral rule of law, we should look for reliable standards. I like the consumer welfare standard. I'm prepared to defend it. I'm also prepared to hear real arguments about where it's fallen down and how we can improve it or advance it. But the arguments that the populists have issued to date just don't fill this bill.
Thank you, Christian. I particularly appreciate your points about how antitrust is particularly over the years, it's been asked to serve too many masters, too many causes such as economic causes and environmental and sorry, not economic, environmental and so other
civil rights.
Yes, civil rights, exactly. Civil rights, equality, everything else under the sun. And it depends on the enforcer. So to ask a bit of a more pointed question than I usually do to start this off is, why do we see conservatives suddenly choosing Brandeis over Bork now? Does it have anything to do with antitrust at all?
Can I answer that question in a slightly different fashion?
Sure.
Brandeis was a man of two hats. He was the guy who organized the United Shoe Machinery deal, which was the first person who recognized that vertical integration presented all sorts of additional opportunities for antitrust growth. And it was upheld in a very good opinion, Winslow, by Justice Holmes in about 1913 or so. And it was only when you got to 1968, when the foreign competition was in, that they wrecked the company so that the whole market was turned over to importers. He also wrote the Chicago Board of Trade decision, which was an extraordinary decision having to do with forward contracts into the Chicago market. And what he did under a rule of reasons is he managed to give an analysis, which I think had one or two tiny mistakes in it, which took a decision below which had been a per se judgment against the company. And under a rule of reason, he managed to give it a per se judgment in favor of the company. A complete switch over. I've never seen that happen in any other antitrust case. I don't know if Marka and Christian have. So, I mean, he's a very mixed bag. You read The Curse of Bigness, and the book is completely unreadable. If you want to read something else that's completely unreadable, try to read the Brandeis brief that he wrote in Mueller against Oregon in 1908. It is basically a bunch of intellectual foolscap. He has one sentence: Lochner allows you to regulate on the grounds of health. And then he quotes all sorts of domestic and foreign sources, lily, saying that this is a health regulation, missing every relevant issue in the particular case. So he was what I regard as bimodal. There were days when he was an A+ guy, and there were days when he was a kind of a solid D. And so it's very hard to know with Brandeis, this guy, where you really want to come down upon him, because I can't think of anybody else who's been so inconsistent in his abilities. I don't know what Mark and Christian think, but that's my impression of him.
Well, that's not
Yeah,
why you were the Supreme Court justice. To kind of get more to the root of my question, though, is like Christian and Mark were both pointing out, antitrust will be, in the hands of whatever the goals of the enforcers will, why are those in the populist movement not understanding now that the goals of the enforcers will be, the outcomes here, that this will not necessarily work very well in their favor in the long run?
I mean, it depends who you listen to, but some of them acknowledge that and they're comfortable with that. And I think that there's some acceptance that despite the Democratic rhetoric, there's some view that a more democratic process is not going to yield the results that are necessary. So it'll be okay if there's some experts who can properly administer this. And to your question, why are some conservatives okay with this now? I mean, increasingly, it seems like the political climate is one where whatever tools are at hand, will use them, principles be damned. And in antitrust, if you can get on board with antitrust getting to punish your political enemies, some people are okay with that, unfortunately.
There's also, I think, something else about conservatives, which is, what's the definition of a market imperfection? The way in which I tend to look at this, and I think that my co-panelists agree, is there is no market which is perfectly competitive. Every little market's going to have some hiccups in it. So every time you renew a lease, there's some degree of monopoly power that exists on both sides. If you try to figure out how you regulate it, you will not solve that bilateral monopoly problem over $10. What you'll do is you'll wreck the entire market. So there have been a bunch of papers, Glenn Weil, Fiona Scott Morton, Eric Posner, all of which have taken the position, we can find a monopoly in any competitive industry that you want to look to. So you look at the airlines and, there are all sorts of practices they do, but these things are deeply monopolistic. What they do is they identify, if they're lucky, a 1% deviation from the competitive situation and have remedies which are far worse than the disease. Eric Posner the other day presented a paper which I took strong exception. He said, my terrible mistake was to think that labor markets turn out to be competitive. He says, you look at these huge data sets and there's all sorts of monopoly power. Well, that may be true when you have an individual employer dealing with an individual employee. I don't know how you divide that surplus, but they seem to know. But when you're talking about labor markets, is it basically a monopsonistic market by these buyers of labor when you have two firms bidding for the same worker and so forth? Do you really think it's monopoly power when in a bad season, many people get laid off and in a good season, many more people quit? To my mind, that what you're doing is you're taking a fly speck of one particular issue and then using that imperfection to lever the whole system. Ronald Coase had a much better view on this. He said, look, this is all a consequence of positive transaction. And if you want to treat positive transactions as a sign of monopoly, then you're always going to go too far. And the distance between what we're talking about here and the old-fashioned sugar cartels is so far that it simply boggles the mind to see that these modern analysts treat the two things as though they're the same. I don't know what Christian and Mark think, but I think this is important to state.
Yeah, to try and answer your question, Ashley, I struggle with it because one, I don't know who falls into the bucket of conservatives. And I always struggle to being able to read other people's minds anyway. So I'm not sure I'm good at answering that question, except for the general observation that regardless of one's political philosophy, if there's money left on the table and you think you can grab it, people will tend to grab it. And giving someone in government a lot of discretion to punish enemies and do favors for friends, regardless of political philosophy, a lot of people will fall for that temptation. Let me add something to things that Richard and Christian had said, sort of about Brandeis and the neo-Brandeisians. I think one of the things that we see is that they're incredibly good at marketing their ideas. As I've read Brandeis, he has a very passionate language that gets people riled up. And my sister, one of my sisters, is a best-selling author, incredibly good writer. I had her look at some of the writings of the neo-Brandeisians, and she said, wow, these people are amazing writers. They're really good at marketing their ideas. And that's true here. So regardless of what the evidence is, the marketing is really good. And one more thing on the evidence that we did talk about, when you look at the economic writings, where they try to put numbers together, essentially, as I read them, the essential argument against the consumer welfare standard is that it's not the same as an anti-business standard. So they'll do do analyses that say, look, companies are bigger. That proves that antitrust has failed, and so consumer welfare standard is bad. But they simply changed the metrics and said, well, it doesn't meet our metrics, so therefore it's bad. And that's just a bad way of doing research.
Yeah, and to just add to Mark's point on the marketing side of things, they are very good with fiery rhetoric. And then essentially the position that I have, and I think Richard and Mark probably have, is something more like, wait a minute, everybody, let's stop and think about what's going on in this particular case and talk about the economic intricacies of it, which is a much harder marketing sell. Saying, promoting general rule of law and, separation of powers is a hard sell when there's people who are really angry.
That's a great point.
You're muted, Richard.
That they turn out to be angry is it's much easier to argue that there's been theft by the big rich guys, to which we now have to restore it. So they have a theory of Aristotelian restorative justice that's going on in there. And when you try to explain to people, particularly those people in the popular situation, about incentive effects, double marginalization kinds of problems, brand affinities, you really have to develop a much more micro analysis of the particular problem, and that loses audience. So, I mean, if you're actually in a public audience and so forth, the only way that you could combat is to sort of scream back at the same level of generalities that they're coming at you. And frankly, that just isn't part of our sort of psychological temperamental thing. I have been forced to do that more times than I care to mention. But it's not because I start that way. It's because what happens is that if I say something like, it turns out that there's a lot of efficiencies in, say, using various kinds of cooperative ventures in order to deal with standard essential patents and so forth, there's always going to be somebody in the audience who said this is just a giant ripoff of you name the group. And then what you have to do is, to some extent, you can't be meek in response to indignation. You have to show a little bit of indignation yourself. On this panel, I don't think we're going to get to yell at each other.
Well, but you know what, though? I think that some of the populists really like going after, every large firm, but they're really on the digital platforms frequently.
Yes.
And I think that they actually leave themselves open to some of that rhetorical fire right back, especially in the wake of the pandemic, where everyone came to realize exactly how useful a lot of the digital platforms were in our daily lives. So when they say, oh, well, we want to break up Amazon because of this and that, it's like, well, there's people who can see demonstratively why Amazon makes their lives better with its shipping network and its back end, having access to information through Google and keeping in touch with people through Facebook. This is something that goes into people's daily lives, and they can actually see that. So when a populist comes in and says, "Oh, but they're evil because they're big," you have an in, I think, to have like a more subjective conversation, let's say.
There's also the following irony. When you're dealing with companies like this, there are two issues. There's size and concentration, and then there's also political bias. And, there's a very profound difference between what Zuckerberg, who seems to have developed the brain around his original technical skill, who says, I'm not going to get in the business of censorship, and Jack Dorsey, who's sitting there on Twitter saying, I'm going to basically tell the public that they want to read a Donald Trump thing, they have to know from me personally that it's inflammatory and arguably racist and hyperbolic and so forth. What has happened is, at this point, you've got political bias. And is there any on privacy invasions and those sorts? And one of the things that you have to say is it's not at all clear that breaking these companies up are going to be able to deal in any way, shape, or form with these particular kinds of interests, particularly if you have two left-wing heads of the divided Twitter 1 and Twitter 2. That's not going to solve this problem. With privacy, the more firms you have, the more difficult it is to chase it down. That was Brandeis's original insight with respect to vertical integration. Something goes wrong with an integrated product, call it a shoe. And I don't know whether to sue the guy who made the sole or the heel, but if the company says, we'll take care of all this and work out the internal adjustments, we're all better off in terms of what's going on. And so the antitrust stuff is oftentimes orthogonal to everything else that's going on in this kind of space. And then when you start having various kinds of privacy regulations, it's not an antitrust problem at all. What people have to realize is any bit of information that you put on a site as part of a commercial transaction is probably going to have to be used 20, 30, or 40 times for all sorts of purposes, most of which are completely legitimate. And if you start having barriers on the way in which this stuff can shift down, you're going to make it very difficult, for example, to identify medical trends, where the hot spots are going to be with one kind of disease or another. And I just don't think there's enough appreciation of the way in which this aggregation extraction of information at the back end, it is monetizable, but it is also beneficial for people like us who no longer have to try to figure out how to do these things ourselves because others have done it for us. Mark is nodding.
Yeah.
Does anyone have anything to say about any of the, I mean, I know there are a lot of recent proposals in Congress out there, particularly to, you know, almost that's the consumer welfare standard. We have a report coming out probably with the House Judiciary Committee pretty soon. Does anyone have any commentary on any of those proposals?
It's hard to have comment. Oh, go ahead, Christian. I've been talking enough. Christian.
I actually was going to say almost exactly the same thing that you said. It's hard to have commentary on them in particular because it's hard to know. It's hard to know exactly where the serious efforts are. So you see the same thing in analogous area with Section 230 reform stuff that's going on. To me, a lot of it seems like saber rattling, trying to extract concessions from the large companies that they're targeting. Because if we're being serious about antitrust, short of there being some sort of strange come together moment in Congress where they decide that they're going to institute new standards, I don't see that really moving. Instead, what there's going to be to try to push to get the agencies to sort of push back on the companies that are disfavored right now. And I think it's a political maneuvering ploy to some extent, because I just don't see this legislation really pushing through Congress right now. Now, after the election, who knows?
I agree. It's hard to say. A lot of it's merger oriented. I mean, it's a pretty radical idea that some of them have regarding, you know, mergers. I mean, some of it would take us back to 1968. I feel like I'm sorry, Professor Epstein, you can go ahead with.
Yeah, no. But I was thinking of, for example, Christine Varney takes over in the Obama administration. She does one, I think, dumb thing, which is she says that the Bush administration report dealing with various kinds of combination activities was wrong, and she basically wants to undo some of it. But you know, she didn't do anything there. And then you start looking at the next 7 or 8 years under her and her successors, and there's nothing about the Obama administration on antitrust law that gives rise to the hackles that I feel about its behavior on environmental areas or civil rights areas at all. I think, in fact, she and her successors were all pretty much in the old antitrust consensus group, which is sort of cautious Chicago types, right? The moment it turns out that, you know, you get Trump into office, all of a sudden the rhetoric on the antitrust laws from the American left is no longer conciliatory, no longer part of this sort of national consensus. It goes the other way. So, for example, I've worked for many years with Qualcomm, and I can say, although I did not participate in the litigation and stuff, I have not read a worse antitrust opinions in years than the one that was written in that case. It was just a ghastly situation. Everything was wrong about it. The citations, the arguments, and so forth. I don't know, maybe Mark or Christian will want to do it. I just get too angry when I talk about the opinion.
Yeah, the Qualcomm opinion, yeah. You go on, Mark.
Chime in on the general topics. One of the things that I have always found useful to keep in mind is that the tech industry, if you will, that's come from Silicon Valley and from Seattle and such, basically ignored Washington, D.C. until the Microsoft antitrust case. And people within the Clinton administration, at least some of them, openly admitted that one of the reasons for the case was to bring their money into D.C., and it worked beautifully. So there's a lot more D.C. lobbying firms now coming from those industries because the government got involved. Until the government was involved, they stayed out into the marketplace. The idea that we could break these companies up and somehow make things better or keep them from merging and make things better. One, I don't know how to split Facebook in half and still have all the communications across between people around the world. I have no idea how you do that. Same thing for Google. Are we just going to tell Google you can complete searches until 2 p.m. and then all bets are off because then you have too big of a market share? I just don't see how any of that works. The prohibitions on mergers just ignores how businesses work, especially in a very dynamic environment. Nobody knows enough about what the technology is going to look like a year from now, 2 years from now, 3 years from now to say, I have the business plan, this is all going to work. They're always looking for what's the idea or the product out there that we can package together, somehow meld into what we have to make it even better. I think what some people fail to realize is that 90% of all the tech startups fail. And that's a lot of money that people are investing in those companies. What they have to aspire to is that at some point we're either going to sell to the big tech companies or we're going to become them. But if we cap off and say you can't get big, a lot of that money starts drying up because a successful product has to, be a good idea. It has to also be a good product. So you have to take from idea to what the scientists and the artists all dream about, and then the engineers have to design it. Then you have to be able to execute a business plan. It's the last thing that they tend to fail at more often than not. And it's the successful companies that say, we know how to run a business. We can take what you've done and do something good for consumers, and consumers are all better off with that.
It would be a total disaster to try to operate a system in which you wanted to oversee the process through the antitrust laws of going from a bright idea in somebody's backyard to a major company. Now, there are issues here, and this goes back to the theme about the right tools that involve. And one of the serious problems that we have is, in many cases, the patent law gives insufficient protection by way of injunctions for small product. There's a wonderful book that's coming out by Jonathan Barnett who talks about this issue, saying in effect that a small company that has a singular asset that it wants to sell into the world can only do it by way of patent protection. Large companies, which tend to be pretty much either mediocre or anti-patent, they can protect by trade secret contractual arrangements and other kinds of business deals, so that paradoxically a weak antitrust law becomes a barrier to a weak patent law becomes a barrier to entry rather than an assist to it. Counterintuitive, but I think by and large it's probably going to be correct. And then it also turns out that the securities law have to really be done in a very precise way, because if you make it too expensive for somebody to go public, what they're going to do is they're going to be bought out. And it's not as though these two are equal alternative routes. Mark mentioned that you could have both of them, but the real difficulty in buying out a small company and putting it into a big company is it now becomes a subdivision. There's going to be oversight layers on it. And the people in large companies don't have the same attitude towards risk that small people do. Small companies, you've got all your eggs in one basket. You know, if you double the size of this particular product, you're going to double your wealth. You make this a 1% division of a large company, you double its output, it's a 1% change on the bottom line. So we essentially really want to do this, not an antitrust problem. It's a patent problem and it's a securities problem. And one of the reasons why I get very nervous today is academic specialization has become a menace to this, because if all you do is antitrust law, then everything's an antitrust problem. If all you do is corporate law, it's that way. What you really have to do is to have people who actually have some industry experience and then try to figure out the multiple areas of law that they have to engage in order to move from the beginning to the end of these processes. I've been lucky enough to have work on a number of these kinds of arrangements, and this is what I've always discovered. So I'm better at theory than all the guys I talk to, and they're better at deals than I am. Why is that? Because they've got experience and their pulse on this stuff. And so what I do is I talk to them, figure out what they're doing, and then try to figure out why they're right, rather than to figure out why they're wrong. And I think if you have that attitude as an academic, it's actually much healthier than the kind of constant skepticism that you see in the academy. Well, we got our PhD, we're smarter than these people. They have done it, and they may not be able to explain it. And this gets you back to the famous stuff having to do with Plato. I don't know if you all care about Greek philosophy, but what always happened is, Socrates was always examine somebody who knew what he was talking about, and then by cross-examination, would take this guy and rip him to shreds. And if you actually knew something about the business, you'd say, well, he's a better advocate. But in fact, the Socrates was the sophist rather than the guy in the search of truth. And that's important to understand, I think, in sort of the general question of intellectual discourse.
I once had the opportunity to talk
I'm sorry, go ahead.
I once had the opportunity, Richard reminded me of this, to speak with some of the academic economists who were on the Department of Justice team attacking Microsoft. And he said they were just so amazed. They would dig through emails and memos by Bill Gates, and he knew more about network economics than they did. And they would go back to their hotel rooms at night and say, he said this, I wonder if it's true. They'd do their mathematical model and find out he was right. And he was doing this by intuition as opposed to all of our analytical proof. So just supports what Richard was talking about.
Yeah. And to get back to what you were talking about, and speaking of not having VC investments, though, or small companies at all, our first Q&A from the audience is about Europe. And it says, will European antitrust enforcement influence US courts? Is Europe already committed to the populist view or some hybrid? I guess that's particularly relevant today as well with the news about Amazon.
The European standards for competition law are different than the US standards. So even if there are cases that proceed in Europe, you may not be able to bring those same cases under current jurisprudence. Ideally, we will stay American and we will convince the Europeans where they're going wrong. That said, I think that's going to be dependent on who you get in the next administration. And back to your previous question, if some of the legislative changes that have been proposed actually start to gain traction, you could see a more European shift. Right now, I don't see a lot of the European cases prevailing in the United States under current doctrine.
I agree with that. I mean, I've spent some time arguing with Europeans, and Kant was a pretty smart guy, but many of his successors are not. And what they do is they take this unduly rigid view of individual autonomy. And what that leads them to believe is that anytime you see somebody make a deal, they're doing something which offends some first principles of natural law. And most of them are not trained in economics. They don't understand the consequentialism, or they don't understand the vocabulary that we're involved in here. And so it's just a huge battle to try to let them understand that, this vocabulary is rather richer than you think it is. It's not when somebody talks about efficiency that they're just a mindless little clone. It's an elaborate set of trade-offs, and you have to have that kind of mind. Europeans are not comfortable with trade-offs, which means that they're not going to get things right very often. That's the first point. The second point is, I agree. I think the American academics, for the most part, well, the courts are reasonably immune to that. You look at something like the Amex case, which came out a couple of years ago, very sophisticated arguments on both sides, no influence, I think, as Christian said, on this. The difficulty is you get big deals like the Honeywell deal and so forth years ago, where you need to get approval from both sides. It's the slowest train that basically, the strictest set of restrictions that determines the speed of the train. You could go only as fast as that. And the problem about the Europeans is I think they're often so confident of themselves that they're basically willing to block America. There's always been a kind of European snobbery about Americans with funny accents not being as smart and as educated as they are. I mean, it really does take place, just the way it turns out that, I've been a lawyer for 52 years, and the number of times I'm told that, well, I mean, you simply as a lawyer do not understand, then you fill in the blank. Any deep philosophical issue, any historical question, any moral question. My attitude is we wander all over the lot. And the exposures that we get to multiple disciplines put us at an enormous advantage over people who spend their time doing one thing. Because if you do only one thing, you tend to do only one thing badly.
I agree with what Richard and Christian have been saying. My experience just talking with Europeans that are working in this space is when they are very comfortable with this one very narrow view of liberty, and that is, I have the right to stop anyone from affecting me, and that really isolates people, and that's going to be hard to live out in practice. But then there is a very comfortable, there's a great comfort with letting geopolitics affect antitrust. And so we see, a lot of this is an American company. We should do something about what it's doing. We're going to raise in Europe the next tech giants, these kinds of ideas. Whereas if they would just simply liberalize the markets and get the government out of the space of trying to pick and choose who the winners might be, some of the European companies might actually become successful. You look at the top 20 tech companies in the world, none of them are European. They're all American or Chinese with a few scattered in from a couple of other places.
I mean, my mother had a statement, which I had to cure. She said, when she was go to the market, she says, if it's a good deal for him, it has to be a bad deal for me. And so all exchange stopped in the Epstein household when that maxim was put into play.
So we have about 4 minutes left here. If each of you have a minute or so for concluding thoughts.
Sure, I can go first since I'll
go last.
I was in the middle before, so let me go first this time. I think it's really important that we focus in on how should laws work, and not so much have a lot of discretion where someone could say, this is my ally, this person helped me get into office, this person, whatever that might be, and let that drive how antitrust works. It's any economy that has gone down that road has been unsuccessful going forward. So I think we definitely want to stay out of that space.
Go ahead.
Yeah, Richard. So following along with what Mark said, the American approach to law is twofold, as I read it. One, evolutionary. We have a common law approach to the way we deal with law, even in the context of antitrust, which is a statutory law. We still interpret it and develop it in common law fashion. And the other thing is we have modularity in the way that we write our laws, and that helps promote a neutral application of the laws. It helps promote the rule of law. What you don't want antitrust to do is to become a meta legislation that overrides legislatures from doing what they're supposed to be doing. And this is an unfortunate trend that I think we see broadly in politics over the last 100 years, where Congress is all too willing to give away lots of its authority over different areas and then complain about the agencies that take over that authority that they gave to them. And I don't think we should allow antitrust to become yet another victim of this trend. Antitrust is really good at doing the one thing it does, which is looking at whether there's competitive harms that harm consumers. And if we don't keep it on that track, I think in the end, we ultimately harm our society.
I will take an even slightly more pessimistic view on this. If one starts to look at the history of development, two premises stand out. One is the progressives always believed that there were never any public choice issues about collective decisions made through political bodies, because they always envisioned themselves in charge. And there was nobody smarter than Felix Frankfurter, and that's what Felix would have told you about all of these issues. And if you read some of his opinions, it's quite clear that he was massively uninformed about how competition and markets work. So the first thing you want to do is to have skepticism on the public choice level, as Jim Buchanan said, about over-romanticizing the way in which these things go. And the second point is, it's not just that you're going to fine-tune the law wrong. If you go back and you look at the New Deal regulation, what these guys did is they had a manual for cartels, and they put them together with incredible rapidity. And these were really damaging. There were agricultural cartels, there were motor vehicle cartels, there were airline cartels, you name it, there were labor cartels. And these guys said, well, this is all wonderful because we now stabilize the returns within the industry. So their attitude was, if they gains to the members of the cartel, that was a social benefit, because they never conceived that there might have been social losses outside of that. And if one starts to think about this, that's the danger of people like Tim Wu and so forth. They're so clever, they're going to start recartelizing other kinds of industries in various sorts of ways. And so it's not just a question of mistuning the burdens of proof in various kinds of integration, vertical or horizontal integration cases. It's the question of going exactly in reverse. And that's the thing that we really have to be careful about. That's the thing that I think that the New Democrats, the Joe Biden, much more liberal than he is personally as an institution, the Bernie Sanders, are likely to bring us if they're elected.
Thank you, Professor Epstein. And thank you to all of our panelists. We're out of time now, but I'd like to thank all of you for coming out today. I think it's a really great, really productive discussion, and thanks to everyone who tuned in. I'll have this video up on YouTube later, and I'll send it out to everyone. Thank you, and have a great rest of the day.
Will you send it to us?
Yes, I will.
Thank you.
Thanks, everybody.
It was a great session, guys. Say hi to Jeff Manning before you leave, Christian. Now, remember we were talking about Roman law. Do you know who one of my prize Roman law students was?
Was it Jeff?
He was my Roman law student.
Yeah.
At the University of Chicago.
He hasn't talked to me about any Roman law. I'm going to have to ask him about that.
But he actually was an extremely astute Roman lawyer. I can believe it.
Thank you for coming out.
I'll tell him.
Okay. Okay, you tell him that, okay?
Bye,
Take care. Nice seeing you all. Bye-bye.
Thanks, Ashley. Bye-bye.
Bye.